Okay, you should have received a notice that we are now recording our training today on firearms and domestic violence. And we are joined today by the wonderful Darren Mitchell and Judge Susan Carbon. And I'm going to introduce them beginning with Judge Carbon. Judge Susan Carbon, I'm going to go in reverse order. She most recently was a justice in the New Hampshire Circuit Courts from 2013 to 2021. Prior to that, she was a special justice in the New Hampshire Circuit Court. Prior to that, she served as the director for the Office on Violence Against Women with the U.S. Justice Department. Prior to that, she served as a family division judge in Grafton County Family Division, and prior to that, a district court judge, having been appointed first to the bench as a district court judge in 1991. And she also served as supervisory judge of the New Hampshire Judicial Branch Family Division. She was a member of the Governor's Commission on Domestic and Sexual Violence and chaired New Hampshire's Domestic Violence Fatality Review Committee. She was the chair of Grafton County, New Hampshire Green Book Project, which we're all familiar with, a collaboration with the U.S. Department of Justice and Health and Human Services I'm sorry, can y'all hear me? Can everybody hear me? Okay. All right, to improve practices where child protection cases intersect with domestic violence. She also was also lead model court judge in New Hampshire for the nationwide initiative of the National Council of Juvenile and Family Court Judges to improve court practices surrounding child protection cases, focusing on foster care and adoption. She served as the NCJ-FCJ president, that's the National Council of Juvenile and Family Court Judges, from 2007 to 2008. She was president of the New Hampshire State Bar Association, and she's also worked with the Association of Family and Conciliation Courts on two of their major initiatives conducted at the Wingspread Conference Center. Judge Carbon, your bio says Miss Carbon, has trained judges and other professionals across the country and internationally on topics related to family violence, firearms, child custody, and child protection, and has published extensively on these and other topics, including judicial selection and retention and judicial administration. So thank you to Judge Susan Carbon for joining us. We are honored to have you today. We also are joined by the wonderful Darren Mitchell, who many of you may have already met and worked with here in Bexar County in a lot of our efforts. Darren Mitchell is a consultant on domestic violence and other violence against women issues with a focus on child custody and domestic violence, firearms and domestic violence, interstate child custody, protection order issuance and enforcement, and full faith and credit. Since 2000, he has trained judges, attorneys, advocates, and other professionals across the country and has published several articles on these topics. His consulting clients include the National Council of Juvenile and Family Court Judges, the Maryland Network Against Domestic Violence, the Center for Court Innovation, the Legal Resource Center on Violence Against Women, the Battered Women's Justice Project, and other national and state organizations. He was co-executive director of the Legal Resource Center, and he's managed the National Center on Full Faith and Credit. Prior to that, he was also a staff attorney with the NCFFC, a consumer advocate, a litigator in private practice, and a clerk to a federal district court judge. So welcome to both of our incredible panelists. Thank you for joining us today. I will now turn over the mic to our presenters, and folks, please pay attention to the chat. Our presenters will be asking you some questions and we'll be monitoring questions that you might have and that you're welcome to place in the chat throughout the presentation. And as a reminder, we will be going until 1:30 p.m. today. I know some of you may have dockets that you have to get back to before then, so feel free to excuse yourself when you need to. The recording will be made available to everyone after we are done. Thank you very much. Darren, Judge Carbon.
Thank you, Judge Diaz. This is a very kind introduction. And I want to thank you for inviting all of your colleagues to a session that we have here this afternoon on protecting victims and communities from firearms in civil and criminal domestic violence cases, collaborative strategies for Bexar County. I think when Judge Diaz gave the introductions, she said it all when she was talking about Darren and describing him as wonderful. I will share with all of you that Darren has been probably the premier national resource on all things domestic violence, and in particular on domestic violence and firearms. And when we have questions, Darren is our go-to person, so you certainly have picked the right person to work with, and it's always a privilege to get to work with Darren. So I'm going to turn it over to Darren. We will call one another Darren and Sue, so I hope nobody's offended by our use of first names with one another. But let me turn it to Darren first for a couple of questions of all of you, and then we will get into the program. But thank you again for joining us today. I truly hope you will find some useful information and some new information that might help you do the work that you are doing now. So Darren.
Thank you, Sue. And you heard from Sue's introduction, the amazing background she's had. So I've basically been writing her coattails since we first met in like 2001. And in fact, one of the first things that we did together was draft an article. We wrote an article on firearms and domestic violence. I think it was published around 2004, 2005 or something. And it's still out there. Many of the ideas are still relevant, but we've learned an awful lot since then. And that's part of what we're going to hopefully share with you over the course of today. So thank you so much for the warm introduction and for being with us. And we would love to get to know, although I already know some of you, Judge Carbon doesn't know everyone, and I'm sure you don't all know each other. So what we'd love for you to do, if you don't mind, is to use the chat function. And if you could chat in your name, and then if you could also include, if you're a judicial officer, how many years you've been on the bench and how many years you've been hearing or had involvement in cases that involve domestic violence. That would be really great. And also, I'm asking for a lot, so you don't have to give us everything, but whether you primarily hear a civil or criminal docket. If you're not a judicial officer, please feel free to type in your name and your role. Thank you. So we'll let some of those get going here, and then we'll start up our presentation in a moment.
Staff attorney, 2.5.
So while those are rolling in, I'm going to go ahead and get the presentation rolling. And Judge Carbon will talk to us a little bit about our learning objectives for today. So let me start the show and make sure that everyone can see it. Is it visible?
Everybody see? Yeah, perfect. Okay, great. Thank you.
And I see we have, it's great to see all of you. We have a lot of experience on the call, and we're hoping one of our main goals, and Judge Carbon is going to talk about the specific learning objectives, but we really want to make this something that's useful for you all. So please do ask questions, slow us down, stop us. We don't have a set of materials that we have to get through. We want to make this as informative and practical for you all as possible. So, we really welcome your involvement and to make this as interactive as possible.
Yeah, absolutely. We'll stop sort of midway or maybe 2/3 of the way to make sure that we're giving everybody a chance to ask questions. But if you have any as we're going through, please do ask. There's no need for us to get through every single thing that we've planned for today, so feel free to interrupt us at any point in time. So we do have 4 kind of overarching learning objectives, and our goal for this afternoon's session is going to be 4-fold. We really hope that you're going to get a better sense of the public health effects of prohibited DV offenders, access to firearms in Texas and across the country, and some effective interventions to use when we have the intersection of domestic violence and firearms, and how we can make victims and communities safer when we're addressing firearms. We'll also give a little bit of background about the federal and the Texas laws that address firearms and domestic violence. We won't get too heavily in depth, but enough to make sure everyone is grounded on these principles. And then we're going to be talking about some effective court and legal systems, so not just court strategies, for addressing firearms in both civil protection order cases and then also in criminal cases. So we want to make sure that we address both, but we will be beginning with the civil protection order process as our starting point here. So Darren, if you'd like to start addressing why we care.
Yeah, and so I know many of you have been involved in these efforts, and some of you may be newer to them. So just get us all grounded in our approach to this. Why is it so important to be thinking about this? And it's really based on a public health focus. It's about trying to protect vulnerable people from homicide, essentially, when a gun becomes involved in a domestic violence case. So the most state-of-the-art research around the risk factors for intimate partner homicide, and specifically femicide, men murdering women, in the work of Dr. Jacqueline Campbell of Johns Hopkins University, has shown that firearms are one of the single greatest risk factors. And it's not ownership of a gun, possession of a gun, it's access to a firearm. And especially when combined with other risk factors, of which I'm sure many of you are aware, the risk is certainly elevated in these cases. So it's a point at which we can try to get firearms out of the hands of people who are at their most dangerous. Research also shows that the mere presence of a firearm in a home dramatically increases the risk of homicide within that home, where there's an intimate partner relationship in the home, and also a very significant increase where within that home there's a prior history of domestic violence. It becomes 20 times more likely that there will be a homicide in the home if there's a gun present where there was a history of violence. Guns are certainly the weapon of choice for domestic violence perpetrators who commit homicides. And so we summarize some of the research here. This is very consistent over the years. Anywhere between about 55 and 70% of homicides in which a spouse or ex-spouse who is a woman has been killed involves a firearm as the weapon the perpetrator used. Texas, similarly, according to data that's been compiled annually by the Texas Council on Family Violence, shows a very similar number. Your average over the last, I guess that's 6 years, of where data was collected is about 64%. About 2/3 of the cases where women are killed by men in Texas involve firearms. In addition to this risk of lethal violence, research also shows that firearms are used as a tool to exercise power and control over victims, and specifically coercive control. So that type of abuse that's based on intimidation, domination, threats, is often based upon the abuser's access and threats made to use their firearms. Susan Sorensen of Pennsylvania State University has done a bunch of research in this area, and a study was just released in the last couple of months building on that research, looking at the experience in North Carolina and corroborating a lot of Susan Sorensen's findings around abusers not just using guns to perpetrate lethal violence, but to use it as one of the tools in their toolkit to exercise power and control over victims. Now, what can we do about that? And you all in Texas have some laws, in other parts of the country, and there's a federal law as well that addresses domestic violence perpetrators' access to weapons. Do those laws have an impact? And the initial research that we've seen in this area show that yes, there is an impact where in the protection order or protective order context, there are prohibitions, as in Texas, built into the law for domestic violence perpetrators. They've seen reductions in a state level study of around 6% in the ultimate, whether there's intimate partner homicide reduction, and almost 20% in a large city study. These studies are ongoing, and as some of you may know, research around firearms in general in the United States has been underfunded and has not been available from certain federal funding streams, including the CDC's, until recently. And we're starting to see more and more studies. And we, of course, are most interested in the implementation of the laws and the prohibitions, and which interventions or implementation strategies are most effective. And we're starting to see more and more of that research being done, which we're very excited about. One of the things that the research shows is that perpetrators who don't have access to firearms don't often find other weapons to commit the crimes. And so the research shows that when these laws take effect and there's a reduction in intimate partner homicide overall, that follows the gun laws being in place. And so because there's a reduction, that tells you that perpetrators aren't using other means to commit these crimes. The overall rate of intimate partner homicide is reducing, not just gun-related intimate partner violence. There have been some more recent studies, and April Zioli, a professor at Michigan State University, is really at the forefront of all of this. She looked at IPV, intimate partner homicides, in 45 states over a very long period of time, and found that states where there were firearms restrictions that were triggered by protective orders, as in Texas, she found a 9% reduction over that time period. If that applies to emergency protection orders, ex parte orders, there's a further reduction, up to 12% reduction in intimate partner homicides. And if there are mandatory surrender provisions, that jumps up to 22% reduction. And as I know from the work with the many amazing people in Bexar County trying to enhance your response to domestic violence firearms perpetration, these are all things that are on the table for you all. Ex parte, prohibitions, and surrender or transfer of firearms. So there's a reason to try to continue to do that. I'm going to turn it over to Sue to talk a little bit about one aspect of this that we often encounter in our work.
Sure. And I think those numbers are really telling because they are very instructive and illuminating how helpful these steps can be when we're putting them together. But I myself and a lot of my colleagues have been guilty of the big but, if you will. So we ask ourselves, why are we doing all of this when we say, but he can get a gun illegally no matter what we do? And I often struggled with that question early on, and I would say, sure, we have this provision and we have this provision, but still, and I'll always use that, but still, the defendant can go to a gun show or buy a gun from a friend or borrow the neighbor's gun or whatever they may do. And there are loopholes out there that are all over the place. We talk often about being able to drive a truck through all of the loopholes. But I think it's a matter of viewing this not as a glass being half empty, but a glass being half full. And if we look at this and we say we really need to do everything humanly possible to prevent prohibited persons from having access to firearms, we start looking at this issue as what can we do to help prevent, rather than, yeah, but there are loopholes, okay? It's a very different perspective, and it really orients us as judges to say, you know what, we have an affirmative obligation to try to make our communities safer. And if we can look at this to say, how can we make that glass half full and keep adding tools to that glass to make sure that we can enhance protection for communities rather than just looking at a system that may not be exactly perfect. We also have to remember that lots of defendants want to be able to comply. We can't assume, like we sometimes can be jaded in saying, well, they're not going to follow the law anyway. Many do want to comply, and they want to know how to comply. And so it's our job to instruct them on what they need to be able to do to comply. And we have defense attorneys who will advise their clients, you really need to follow the law. And these are important laws. They need to be honored. And so here are the steps that we can take. Another way of looking at this is there's some great research by Daniel Webster, who is a scholar in the School of Public Health at Johns Hopkins University. And he's got a great quote here that I want to remind people of. He says, yes, some criminals will be able to steal or purchase guns already in circulation. That's the yes, indeed. But many of the estimated 300 million guns, that number is still staggering, in civilian hands can't be easily acquired by criminals. Lots of gun owners lock their guns in safes or have other ways to secure their firearms. practices that can be increased by laws and educational campaigns. And these are the kinds of things you're talking about in Texas. And it's not as easy or risk-free for criminals to buy guns in the underground market as is commonly believed. Duke economist Philip Cook has studied Chicago's underground gun market and said there may be lots of guns, but there's also a shortage of trusted sellers. And with the greater accountability measures and choking the supply of new guns into the underground market, street prices will rise and potentially fewer dangerous people will have access to guns. So these are important considerations, and it's really critical, I think, for us to look at what we have and do our very best to build upon that. Remember that getting some guns out of the hands of people who are prohibited is better than no guns. And so even if it's not a perfect system, it's better than nothing. So don't let perfect be the enemy of the good. Look at what you can do. Look at how you can build a tighter system and take joy in the fact that you are making improvements as you go. Don't expect to be able to jump from 0 to 100 in a perfect system, because I don't know any jurisdiction around the country that is perfect, but lots of them are taking really important steps and not getting bogged down by the but issue. Okay, so Darren?
Yeah, thank you. So now let's talk a little bit about the law. And as Sue said, we're going to not spend a ton of time on this, but we want people grounded on some of the legal authority that's out there, both federally and in Texas. And so on the federal side, there are really two parts of the federal gun laws that we focus on in this area. One is around the Federal Gun Control Act. We'll talk about those provisions briefly, and then the Brady Act, or the Brady Handgun Violence Prevention Act, which is focused on purchases or transfers of firearms. On the Federal Gun Control Act side of things, until 2004, with the enactment of VAWA, the Violence Against Women Act, there were a set of 7 sets of circumstances that could render you prohibited from possessing, purchasing, or transferring a firearm, based on whether you were if you had been convicted of a felony, if you were under indictment, if you had been dishonorably discharged from the military, you had involuntary mental health commitment, things like that. But in 2004, as part of the Violence Against Women Act package, Congress decided that it was important to try to stop a set of people who have been adjudicated as among the most dangerous from having access to weapons. And that is folks who are subject to domestic violence protective orders. And so Congress enacted Section 922G8, and there are some requirements that your protection orders have to fall within in order to be prohibiting protection orders. And of course, it's only for the duration of the order. And I'm not going to go into the details of that, except to say that the orders that you all are issuing in Bexar County and in Texas in general, generally speaking, fall within that prohibition. They have the kind of prohibitory language and the relationship requirements that are necessary. The second aspect occurred a couple of years later, when for the first time Congress decided that in addition to certain felons, there are a set of misdemeanants, people who've been convicted of domestic violence misdemeanors, who should be prohibited, again, for their dangerousness. And that is the so-called Lautenberg Amendment, because it was first introduced by Senator Frank Lautenberg from New Jersey. And it makes it illegal to possess, purchase a weapon if you are subject to a particular kind of domestic violence, or if you've been convicted of a particular kind of domestic violence offense. There are a lot of details around what the elements of the offense are, what the relationship must be, and in some instances, there's a determination that has to be made by the feds if they want to bring a prosecution or to stop a firearms purchase to make sure that the conviction and the relationship requirements are satisfied. Again, I'm not going to go into details that could take a very long time to dig into. If you have questions, we're happy to answer them, and we can provide you with copies of the law and some explanatory material. But know that the federal law prohibits both people subject to protective orders and people convicted of misdemeanor crimes of domestic violence, as well, of course, as of felony domestic violence convictions from possessing firearms. And if you knowingly transfer a firearm to someone who is under one of these prohibitions, you too are breaking federal law. You're out of compliance with Section 922D, which parallels G and says that you can't knowingly transfer a firearm or ammunition to someone who has a protection order or was convicted of a misdemeanor crime of domestic violence. The other part of the federal law that we want to briefly touch upon is the Brady Act, which stops purchases of firearms. The Brady Act has basically says that there is a 3 business day period in which, after you try to buy a gun from a licensed dealer, the licensed dealer has to ensure that a background check is made by you. And it occurs differently in different states, but essentially what happens is the background check folks have access to your criminal record, to databases of protection orders, and other things, and has 3 days in which to determine that you are allowed to get the gun for you to be able to walk away with it. If that background check is not done within 3 business days, you get to proceed with the sale. And then if subsequently folks find out that you actually were prohibited, ATF has to come in and try to get the gun back from the person to whom the gun was sold. And so we spent a lot of time talking about trying to ensure that the Brady system is functioning well. And that means getting orders into the state and ultimately federal databases, getting conviction information that's accurate into the federal database, the III database, and ensuring that courts respond to inquiries from the background check folks at the National Instant Criminal Background Check System to ensure that information about purchases that shouldn't be made are available to folks. On the Texas side of things, and you all know your code, so I'm really not going to go into much detail at all here, just to highlight a couple of select provisions. As I'm sure you know, Texas law makes it a crime to possess a firearm once you've been notified that a civil protection order is in place against you. It's been interpreted to include ex parte and final protection orders, and also orders from other states that fall within the definition in the Texas Penal Code. In addition, as a judge issuing a protective order, you have the discretion to prohibit the person from possessing a firearm, with the exception that a peace officer who's actively engaged in employment as a sworn officer is allowed to have that duty weapon. This provision has been interpreted by your state, by the AOC in the state, in putting together a bench book for judges around domestic violence to include the ability for you to order surrender or transfer of firearms from those who are prohibited. Sorry, I'm having a little trouble with my computer here. So why don't we stop for a second and that slide didn't show properly, and see if there are any questions or comments on what we've talked about so far.
So any questions on the why we care about this, or any basic questions on the law before we move forward? Okay. Do feel free. There's no wrong question. So ask anything if you're concerned about any piece that you might not understand.
If I could chime in for a moment, the last thing that we discussed, or that you discussed, Darren, is the exception for peace officers. I have had a couple of my colleagues ask about that exception. And is it your understanding, as it is mine, that there are still some limitations that could be put in place when we're talking about peace officers and their ability to retain their weapons? My understanding is that we can still order, for example, that those weapons are only used throughout the course of their employment, that they're perhaps kept, at their place of employment, or, different limitations around that. Is that y'all's understanding as well of that exception for peace officers?
I can't speak to the Texas law and its interpretation of the Texas law. Unfortunately, I haven't looked into it at all. I can tell you on the federal side, where there's a similar exemption for government, it's written as government employees who use weapons as part of their duties. That there's a similar exception carved out, and that's exactly how that's been interpreted by ATF and by others. That that departments can impose and judges can impose certain limitations around that person's access to a weapon. And of course, departments can be more restrictive. And we know of many police departments or law enforcement agencies that say if you have a protection order against you, you're going to go on a desk duty. You're not going to use your gun at all. And so, yes, that's if it's consistent with how the federal law is interpreted, that would be absolutely be true.
Thank you.
Well, and if I could just add a little bit from experience in years past, when there's a law enforcement officer involved, it's gonna deviate and be much more detailed than the form protective order. I've carved out provisions, and I'm sure Richard has too, identifying who's to keep the safe, where's the safe to be located, and the hours of possession permitted. So those provisions and that carve out can be as restricted and identifiable as the litigants and the bench require.
Yeah, great. Thank you. And I see Judge DeLeon, hi Judge, has asked a question about the military and whether the military consistently informs the national database, the National Criminal Information Center's databases of convictions or indictments so that the folks who are doing the background checks can see them. And as I think many of us know, that was part of the issue in one of the El Paso, I believe, although I may be wrong about that there has not been consistent, strong entry of orders or conviction orders into the national databases. Oh, Sutherland Springs, thank you. Yes, absolutely. And so that's something I know the military is working on, but I don't think we can rely on consistency at this point based on my understanding. And of course, I shouldn't say of course, but the federal law is very specific as to what's prohibiting. And sometimes, military convictions may not apply in instances. Military orders issued by commanding officers may not be prohibiting in the same way under this federal law as your state court orders. And so there are some nuances around military involvement as well. And if folks have questions about the military aspect, I actually have a couple experts that I can refer you to who have given a lot of thought to those issues. Okay. I'm sorry, Sue, the slide is somehow not showing, but.
Okay, we can go on to the next one, that's fine. So we're going to transition now from the why we care and the law into talking about the civil protection order system. Remember we said we were going to talk about improvements to the civil protection order system and then in our criminal context. And we've really looked at the civil protection orders, the system in terms of 6 major categories or 6 buckets of areas where we can make some improvements. And the first is getting the information about firearms. So where are the firearms? Who could we get the information from? What are they? And so forth. So basic data about the firearms. The second category is more from the court standpoint about our responsibility in issuing clear and enforceable surrender orders. Then there's a third category about after we've issued these orders, making sure that everybody understands what the terms and the conditions of those orders are. We talked a moment ago about the importance of defendants understanding what their obligations are. Victim needs to understand what her rights are also under the order and what is being issued. And then as well about enforcement of those orders. And then fourth, this is a really critical area for law enforcement in particular, using service of process as an opportunity to obtain firearms and ensure that we've got the safety built into the system that we're looking for. A fifth area we'll talk about is monitoring compliance to ensure that the orders that we issued in our second bucket of topics here, those orders are actually being followed and that we can track whether they're being followed. And then finally, at the end of the protection order process, Darren mentioned a moment ago that the restrictions last only for the duration of the order, When those orders expire, how can we have a safe mechanism for returning the firearms? So before we get into talking about improving the system itself, I want to touch for a moment on some of the tensions that exist and some of the overarching values that we have in the protection order system. And probably first and foremost is the topic of victim autonomy. We as judges often find that there's some tension between what we might think as judges would make for a safer situation for a particular victim. On the other hand, a victim may say he or she wants X, and we may think that we know better. Well, do we? And do we need to be listening carefully to what it is that a victim is asking for? Even though the law may authorize different forms of relief, are we honoring what it is that the victim wants? And we need to remember that the civil protection order system is indeed a civil system made available to victims as a resource for them. It's not a mandatory state participation process, very different from the criminal system. So we need to look at the victim's autonomy and hope that through our efforts, we can ensure that victims understand how best they can be safe, but recognizing that sometimes there is tension between what they ask for and what we think might ensure their safety. And on the other side of this, we also have to be sure that at every single stage of the process, we are honoring respondents' rights. If we engage in the civil protection order system and we're not following all of the due process requirements, then the system itself fails. I apologize if you're hearing sirens in the background. I'm in a hotel room and there's a lot of sirens going by. So I'm sorry if that's interrupting your ability to hear what we're saying here today. But we do have that responsibility as well to ensure that we are respecting respondents' due process rights. That's a key value. And then as well, we also need to be very sensitive to the populations of people we are working with. Our job is to serve those who come before us. We need to make and realize that not everybody comes from the same background that we do. There may be people who come to court who have immense distrust for court systems. They may come from cultures where judges were corrupt or where law enforcement couldn't be trusted. So our job is to make sure that we are explaining what relief we can offer and then make sure that they understand what it is that we're providing for them and that they have the right to request or not request certain forms of relief. So with that, let's move into the first category, which is getting the information about the firearms. How do we get the information and where do we get it from? The title of our presentation this afternoon addresses the importance of collaboration. And this is really the first major area where collaboration is front and center in everything that we do. And it forms the foundation for all of our work in protection orders. We can obtain information about firearms or firearms possession from many, many different sources. And one of the most important is actually getting information from advocates who work with victims, petitioners who are coming to court to ask for relief. Victim advocate organizations may have questionnaires that they may use, or they may have interview guides that they have. If these are questionnaires and interview guides that can be developed through your coordinating councils or other kinds of community groups, then we've got everybody operating on the same page to know what it is that what information is being gathered. Judges and law enforcement can have input on what is going to be requested of victims through the advocate organizations. So these are one great resource, but advocates in particular are very trusted individuals for victims, and they are very often the first person the victim will go to say, hey, I need some help, and an advocate will be there as a confidential advocate to assist that victim. If we're in prosecution mode, it's a little bit different there, but private advocates, nonprofit advocates who can work with victims may be able to get lots of good information and help a victim understand what information it is that will be helpful for us when we're issuing orders. In the court system, when we look at petitions and motions to surrender, lots of states are developing new forms or they're updating their forms to have information that is very specifically related to firearms. asking if firearms were used in any incidents of violence, making sure that victims know that they can ask those firearms be surrendered, and that we would include in our court orders requirements that firearms be surrendered, and that we advise defendants that they may not possess any firearms for the duration of the court order. Court process very often is forms driven. So if we have forms that address firearms, we are more likely as judges to gather the information that we need to later then be able to issue orders that can engender greater support and make for a safer process all the way through. We may have supplemental forms that we use in the court system and as well for law enforcement. And then moving on to the law enforcement incident reports themselves. So we've got advocates, courts, now law enforcement on their incident reports when they respond to a scene, whether they make an arrest or not, they will have an incident report that may discuss a circumstance where a victim was seeking an emergency protection order. And those incident reports will include language and information about whether there were firearms used, if there were any at the scene, if a victim knows if there are any that are potentially held elsewhere by the defendant. So all of that kind of information can be very useful. Having training for everybody who is involved in the process so we know what firearms laws exist, what the protocols are, and making certain that everyone understands what each other's protocols and responsibilities are can help make a tighter system so that we really design a seamless approach to gathering information as the first step toward issuing good protection orders. But making certain that we all have that training, that cross system training can help all of us do our jobs better. Another good way to get information is for us to provide information to victims through informational brochures so that they understand what their rights are as victims, what the laws are in your own jurisdiction, so they know what relief they can actually request when it comes to firearms and domestic violence. Another piece we'll touch upon that we mentioned before, cultural considerations and language access. Make certain that in addition to English and likely Spanish, that all of the other languages of the populations who come to your courts have access so that they can understand every bit of what is going on in court, particularly around firearms. Whether you've got language bank or language access resources, make certain that everybody's got access regardless of whatever language or dialect within a language they may speak. And then finally, civil and criminal records are also other really good sources of information about a defendant's access to guns. And sometimes states will have specific protocols on this. And if not, oftentimes you let folks know that you are going to be examining those other records so that you're disclosing the fact that you are looking at other court records for this information. So this is a good example of a form where it's very specific. This is for a victim to request if they're asking for firearms to be surrendered by a defendant. Here's the respondent's name and all of the data about the respondent so that this information can go to law enforcement when that protective order is going to be served. So just a good example there. Getting the information. This is another critical piece here. This is a good example of a form that comes out of Wisconsin. And this is one that the petitioner completes here. It's the petitioner's statement of the respondent's possession of firearms. You'll see that little title underneath at the very top, State of Wisconsin Circuit Court. So this is where the petitioner will fill in and respond to these questions. Do you know whether the respondent has access to firearms or they currently have any in their possession or within whatever period of time Wisconsin picks 6 months? And it allows them to then fill in the firearm, the number of guns, the make and model, serial numbers, locations, all of this sort of very important information that will be helpful to law enforcement when they go to serve that protective order, where they're being ordered to surrender those firearms.
And I just wanted to point out quickly, Sue, that this is an optional form. It's not required. And so the goal in Wisconsin is that the victim will have a confidential conversation with someone to discuss what it means to submit this form to the court, what will happen and follow up and all that. So it's a kind of an informed, optional choice for victims, in particular civil protection order cases there.
And Darren, that was important. It does say that it is optional, but sometimes by asking this information, or if the courts can say, we really want this information, it takes the burden off of the petitioner, who sometimes may be reluctant to provide the information for fear of reprisal. So it's a good point that in Wisconsin, they've elected to make this optional. So thank you. Okay. This one, on the other hand, is the respondent's sworn statement of possession of firearms, ammunition, or other concealed weapons, and their concealed weapons permit. And it asks the respondent to provide information about their own ownership or possession or access to firearms and ammunition. This one comes out of Miami-Dade County. This raises some interesting Fifth Amendment issues that jurisdictions around the country are sometimes wrestling with. Some have absolutely no problem, and it's a non-issue. In other jurisdictions, it can be more challenging, but it works like a charm in Miami-Dade County. And respondents complete these forms, and it helps courts and law enforcement as a double check to what a victim may provide to the court. Now, if you're like me, I can tell the difference between a handgun and a long gun. But if somebody asks me to explain the difference between a Colt 45 or a Magnum or whatever, a Glock, you name it, there's no way under the sun I could tell the difference. So people at the Battered Women's Justice Project created this fabulous tool here called the SAFE tool that helps victims be able to actually identify a handgun. Because saying that you've got a handgun when there are so many different varieties really isn't particularly helpful for law enforcement, where they really understand all of the differences. So they have designed this tool. It's something where a victim can literally point at a picture and say, yes, this looks like the gun or the guns, plural, that someone has access to. And that can be very helpful in assisting law enforcement so they know what to look for, as opposed to just saying, well, it's a small gun as opposed to a long gun and a rifle or something like this. So,
and I just wanted to quickly add, Sue, that for those of you on this Zoom training who work with victims around these issues, the SAFE tool is much more than just this. This is a centerpiece that we wanted to show. But what it's designed to do is to facilitate a good confidential conversation between an advocate and a victim about what the options are around firearms, what the potential pitfalls are of telling the court about the guns, and things you can do to keep yourself safe in this whole process. So it's really kind of an overall tool for advocacy in this area. I can't do it now because I'm sharing the PowerPoint, but I'll try to chat in the link to the SAFE tool so those of you who are interested could download it.
Thanks, Darren. It actually is a quite big document and very useful document. And it gets at part of what we talked about earlier about the tension between what relief is available and what we may think or want on behalf of victims. So thank you for clarifying that. The next area we want to talk about is issuing clear and enforceable surrender orders. So the first part was really others gathering information and then providing it to the courts. And now it's up to us to be able to issue orders that are really clear. And in Texas, you've got a terrific order here where it's very specific, very easy to read and follow who the victim is, the protected party, and who the respondent is, and all the identifiers that are necessary for the registry to be able to make sure that we know who it is that we're talking about. But at the very bottom, it carries the language that Darren discussed with you earlier about not the defendant being barred from possessing a firearm or ammunition unless they're a peace officer actively engaged in employment and so forth that we talked about before. So that's a critical piece. This other one then, moving on to issuing effective service orders, what else can we do to make these better? And how else can we improve this court process here? This is another good example from Wisconsin here, where this is an order to surrender firearms and a notice of firearms surrender hearing. So the court is telling a defendant when they've issued an order that requires surrender that you must appear at the surrender hearing because you've been ordered to surrender your firearms. And if you fail to surrender them or relinquish them, and you fail to appear for a hearing, then further court proceedings will follow after this. So the court at the outset sets a hearing date, expects compliance, And if there is no compliance, they go forward with the hearing here. They also have the ability in the next slide here to very specifically track those firearms. And this goes back to the SAFE tool about knowing what they are and being able to develop a grid here where we know specifically what they are, the make, model, serial number, and so forth. So even if you don't have all of this information, being able to provide some of it, again, is more helpful than having none of it at all. So when we're issuing orders, just a reminder, courts should be as specific as possible about what the firearms are that are to be surrendered and seized, and making certain that the language in your order is very clear so the victims know what it is that you're ordering and defendants know what it is that they're required to do. Identifying as well the location, where in the home or in a garage or in a place of employment the firearms are, and then very specific instructions in your court orders about the when, where, and how to surrender. This again requires really strong collaboration with law enforcement because they're the ones who are going to be out in the field gathering those firearms. So the more specific you can be, the more helpful you're going to be all the way down the line.
And I just wanted to add very quickly, Sue, that I know many of you are sitting there thinking, well, I never get this information. I don't have this. I can't. I'd love to be specific, but I can't. And that's certainly true of folks all over the country who are trying to do this work effectively. And what I can tell you in working with several communities that have taken steps to develop the kinds of petition language that we just showed you, or supplemental forms to provide information around guns, as you start to put these things into play and the court and stakeholders start to understand that they're going to be used and what they're useful for, you certainly, as judicial officers, will start to see more information. When people understand that you want it and you're going to do something with it, and there's some trust and faith in the system, you'll find that you'll get more and more information as time goes on. So some of it is about taking a leap and saying, let's provide it and see what happens. We're currently doing the experiment in Vermont. Sue and I, we're working with the state of Vermont on a firearms project, and they've just amended in the last 3 months or so their complaint and affidavit that they use in their protection orders cases to include these kinds of opportunities. And we are starting to hear in practice how it's made a difference for everyone in the system, including judicial officers and officers who are law enforcement officers who are serving orders and trying to get weapons. So, so we're going to have some information from a place that's very actively engaged in this to help us as we work with you and others to see what works, what doesn't work, what could be improved. But it takes taking that first leap and not, again, trying for the perfect. We know you're not going to get this in every case, but start to work on a system that seems like it's good and will work and see what happens.
And to continue building on it is really critically important. So courts should also be facilitating enforcement of the firearm provisions by your collaboration with law enforcement to ensure that the orders that you're issuing are getting into your state and federal registries in a timely way, and making sure that the Brady indicators are accurate and that they're being marked where appropriate. And similarly, to make sure that when you've got all the information, if your registry comes back to you, as from time to time they will, saying, hey, we need some more information before this can actually get uploaded into NICS and be available to law enforcement across your state and nationwide, which is the purpose of having orders into a registry, that you respond to those requests. Because if you don't, then the ability to enforce that order throughout Texas and throughout the country is limited. The whole idea here is protection. And if we're not making certain that our orders are as complete as possible and that all the requirements of the orders are met, it just compromises safety again for victims. So being open and transparent about why you're doing this and the importance of spending the time to do it correctly is really important. And the FBI from time to time will come and audit your system. When they do, work with them because they will help you do a better job with your own registries and your role as court staff to do that as well. So really important here.
So I'm going to take over and talk a little bit about some of the other opportunities that are available in the civil protective order system to learn about guns, take actions to take guns. I want to just quickly acknowledge that I know many of you have been working on incorporating many of these ideas into your system in Bexar County. And so just as part of this is not everyone has been involved in this. We wanted to be able to share with you what we've learned in terms of best practices around the country and provide you with some examples. But I can assure you, having been part of the process, working with Judge Diaz and Judge Alvarez and Judge De Leon and Meza and the groups, that the folks in Bexar County are really incorporating as many as possible of these practices that we've been talking about. But we wanted to give you kind of a broader national view of this stuff as you start to work on what the process should look like in Bexar County, as a bench and as other stakeholders. So the next step that we want to talk about is ensuring understanding. We think about this in terms of setting people up for success. We are not creating a system that is designed to punish people. We're designing a system that is aimed at getting firearms from folks who shouldn't have access to them for all the reasons we laid out at the beginning. And so we want to set people up for success. And to do so, we want to make sure people understand what's required of them and how to fulfill those responsibilities. And so we strongly encourage the use of frequently asked questions or informational materials like this one from Multnomah County, Oregon, which is Portland, Oregon, that answers in simple language what respondents in protective order cases, what they call their FAPA orders, should do to turn in their firearms and where, and all that kind of good information. This, of course, is Oregon specific information. You have Bexar County specific information. We've been working with Vermont on something similar and a couple of other sites as well. But we think that these tools coming along with the order that has now been served on someone can really make the difference in terms of getting compliance, setting people up for success. Part of that is the service of process piece, and not enough communities, although a growing number are, recognizing that that stage in the process where a respondent, an offender, is first served with the order is a critical one, not only for safety to the victim, of course, once the order is served, but also for the officer safety, but also for the respondent, understanding what's expected of them, and again, setting them up for success. So we wanted to talk a little bit. I know this is largely a judicial audience, but you all have a role to play as leaders in your community, and especially in the legal community. So this is a moment for judicial leadership around what law enforcement can be doing and what you as judges can do to support this. And so the most effective systems around service that we have seen are collaborative, the courts involved. In your case, maybe the Family Justice Center or advocates are involved, and of course, law enforcement in developing a protocol that is going to be safe and effective. And so, to give you some examples of what folks do in other parts of the country that works well, is to have someone conduct safety planning prior to service with the victim, specifically about what service is going to look like. When the respondent is given this order, what's going to happen next, how they can keep themselves safe, but also to obtain information about firearms. Maybe it wasn't all in the petition. Law enforcement can learn about the person's access to guns that can help make service more effective and safe. And also just general lethality factors that may be present that the officers are going to want to know moving into this. So this is about officer safety as well as an effective service process. In King County, Washington, and in some parts of Maryland, a service packet is developed so that the serving officers not only have the package that they have to serve on the respondent, but they have their own information about what to expect in terms of guns and in terms of safety. That is really an ideal system. And incorporating into that notification of the victim, whether it's through an advocate, through the Family Justice Center, however it's going to work, that service has taken place, whether guns have been taken, what the result was of service. That's key critical information for safety planning for victims. I don't have to tell you that this is one of the most dangerous parts of the process for victims and for others. And so we want to do everything we can to build in safety measures. We think that having law enforcement have a clear protocol around what to do at service is really important, both in terms of making sure that officers understand what they need to do and can be held accountable to it, and bringing new officers, new serving deputies on board. And that means having very specific instructions around how to ask about weapons, how to try to get surrender of weapons in a kind of a warm approach we sometimes talk about, which is one in which you're not coming in, with guns out and flak jackets on. You're talking to the respondent as a person, trying to explain to them what their requirements are at this point, and seeing if you can get voluntary surrender. What happens if the person denies having guns, that there's indication they do have? What's your next step as a serving officer? Do you just report it back to the court as part of the return of service? Are there steps that your agency wants to take? We're strong proponents of figuring out a safety protocol or a service protocol for agencies. And of course, there are issues around storage, which I'm not going to go into detail now. And to the extent that you have any, we've already had some conversations around that. Happy to continue that. So that's service of process, which we think is, as I said, an underutilized part of this. Monitoring compliance is really kind of the big piece that everyone wants to work on, because we recognize that without some way to monitor whether people are actually complying with orders, what you have is tantamount to an honor system. People who want to comply will, people who don't won't. You'll either never find out about it, or you'll find out about it and be powerless to do anything about the non-compliance. So a lot of energy and attention is focused on this monitoring compliance piece. And I know folks in Bexar County have been focusing on this as well. I just want to lay out for you kind of simply what we consider to be effective elements of a compliance review system, and for you to think about how this potentially could work in Bexar County. We've already talked about clear orders, specific deadlines, what to do, descriptions of firearms, setting people up for success. That's part of monitoring for compliance. Clear instructions of what to do, what kind of proof the court's going to require about what you've done with your weapons. And I know there's been work in Bexar around this as well, needs to be developed. In many places, there are affidavits or declarations that have to be turned into court that attest to whether you've turned in your guns or not. And critically, and you and Bexar County should be very proud of the efforts you've made to develop a whole unit of people who are helping the court in protective order cases, cases involving domestic violence, with a potential focus on firearms, is to have designated personnel at the court who can work on compliance review. Every one of our systems where this works, there are people who are doing it, either in the court or in another stakeholder group, that are making this all work. So we really applaud your efforts in Bexar County to make that happen. So I wanted to share a couple of other ideas around the system, and then we'll look at a couple of forums. The mechanism for reviewing what's happened can involve direct communication between the court and law enforcement. I know that Bexar County has been leaning towards setting a hearing and having the respondent prove compliance with the order, and potentially there won't be a review hearing if the person does comply, but there may be a review hearing if the person doesn't comply. And that is certainly a very effective way that's being used in several courts around the country to monitor whether people have been doing what they're supposed to do. We have judges who will tell you that they find this to be a very efficient process that is actually saves court resources, because it eliminates the need in many cases for contempt hearings that really shouldn't be taking place. It removes the onus from the protected person to do the work. And you can address issues as part of this process that don't require a whole set of much more hearings to address why a person's not complying with orders. If there is non-compliance, and I know this is an active topic in Bexar County, as it is pretty much everywhere that this work is being done, what do you do if people continually don't comply with these orders? What is your authority as a civil protection order court to hold people in contempt, hold a show cause hearing? What's authorized, what's allowed, what about counsel for the respondent? What about the involvement of the prosecution? I'm not going to go into a lot of details around this. There are some solutions out there, and we're happy to talk further with you about what it could look like in Bexar County. I know it's going to be kind of up to you as a bench to be thinking about what you can do in this area. And as you start to get ideas or need more strategies, we're happy to be part of the process of providing you examples. There are courts in Florida, in Georgia, in Washington State, in St. Louis, in Missouri, that are in Wisconsin and Kentucky that are doing this work that we can share the approach with you on. So just a couple of examples around forms. This proof of surrender form that I mentioned earlier, this kind of declaration about what you've done with your guns. This one is from Washington State. All respondents have to turn this in. If they don't, there's follow-up and a review hearing about what they've done with their guns. The option is to give it to your law enforcement agency, and that's really at this stage it. The idea is you can't give the gun to a third party unless the court approves that third party. So you're going to have to give it to law enforcement, and then ultimately it could go to a third party, which is a safe process that's used in other places as well. If you don't have guns, you submit a declaration of non-surrender in Washington State. In Oregon, this is the declaration that they use there. You'll see it gives you options to say, I've surrendered, I've given it to the third party, which is allowed in Oregon, but that requires, as you can see in bullet number 2, an affidavit from the third party and a background check to be completed by the Oregon State Police before that third party can have the weapons. And the court's not going to allow it if that's not completed. And simple example of a receipt that law enforcement can develop and use so that people who do turn in their weapons, transfer their guns to a law enforcement agency, can prove to the court using a simple receipt that's actually happened. In Miami-Dade County, the judges who employ a monitoring process like this hold show cause hearings if people fail to turn in their firearms and/or their affidavits of surrender. And this is the order to show cause why the respondent should not be held in contempt for failing to do what they were supposed to do. So this is to show you that, and this happens in other places in Miami and other cities around the country, that show cause hearings are a tool, and contempt is a tool that's being used in certain courts to ensure compliance with orders. The last piece we'll talk about, and then we're going to open it up, and we hope that people have questions or observations because we've been talking for far too long, is a safe and effective return process. And essentially what that means is to make sure that if an order has expired or has been dismissed or vacated, that guns don't go to the respondent without a check to make sure that the person isn't otherwise prohibited. Maybe there's another protective order. Maybe there's a misdemeanor domestic violence conviction. Maybe there's some other prohibiting factor out there. And so the best practice is to require request a petition to the court to get your weapons back. Many courts hold hearings where the victim can come and object potentially, or doesn't have to come. And a criminal background check is part of that process. And we have an example in North Carolina of the form that's used to ensure that this process is safe and the person is allowed to have their guns. And you can see there are questions on their motion for return of firearms that parallel the questions you have to answer to get a gun when you're trying to buy it. And protocols should be developed collaboratively on this process. So I really want to, I'm going to turn off the slides, and oops, that didn't stop the sharing of the slides. There we go. And ask you if there are any questions, observations, concerns about what we've talked about so far on the civil side of things. So please feel free to either unmute yourself or chat in any questions you have. Judge Carbon and I have given you a lot of examples from a lot of places. I hope that the principles behind what we're talking about have come through. These are all intervention points in the civil protection order process that we think we can take advantage of. And there are some great ideas for how to do so. That's really kind of the bottom line message we want to send for you all. Anything you want to say?
Just an observation on my part for Darren and Judge Carbon is that we talked about not wanting perfection, not expecting perfection. I think that's a good point, because a lot of times I see a lot of, come on, everybody's going to have access to a gun. They are going to find a way to get to it if they really want to. Why are we bothering with this type of trying to get guns? As much as possible, like you said before, and I think it was pretty good, Judge Carbon, just saying that, look, there are, it is for some people hard access to get a weapon without actually going to academy and buying a gun. If they can't pass the background check, then they will have a problem getting to a weapon. So I think that was a very good insight that I actually haven't heard very often, and I appreciate you guys mentioning that. That was just my 2 cents on what you were talking about, Darren.
Thank you, Judge De Leon. I really appreciate that. And I have to tell you that that's kind of our guidepost for this work, because we're trying to do this in a lot of places around the country. And it's hard for us not to feel defeatist at times, right, around this stuff. And I think what keeps us going is knowing that there are folks who really do want to comply with the law. And anytime you get a gun out of one of these situations, you're by definition making it safer.
Exactly.
It's interesting to see around the country how some jurisdictions will take a piece of something and do that really well and say, well, yeah, but we're not doing this, but others are not doing that. And people are building upon what each other is doing and learning from one another to help keep augmenting their process. So every bit helps.
I just wanted to chime in and thank everyone for attending today. And several of the folks in the room have been a part of our ongoing meetings with the Firearm Transfer Subcommittee. And I appreciate Judge Carbon mentioning that this is ongoing work. That is in no way perfect yet, but we are intending for this presentation today to serve as a precursor for the formal introduction of the forms and processes that we have been developing over the last year and a half through the Collaborative Commission on Domestic Violence. So the next steps will be that to all of our esteemed colleagues will be setting up more detailed trainings with you all to go over the forms that we've developed for Bexar County. Many of them you'll see resemble ones that some of the samples that Darren has shown you today. So I hope that this will help set a framework for a better understanding of what we've developed. But more importantly, again, that is ongoing work. And if any of you are interested in being a part of that committee work, we're meeting once a month. And we're happy to add you to the calendar invitation to join those efforts. So if anyone is interested, feel free to message your email address in the chat, and we'll go ahead and add you to those meetings. Once we have met with you all and circulated those forms and processes, please keep in mind that, again, nothing is final. It's a work in progress, and we'll appreciate all of your ongoing input as we start implementing those on the bench. So again, I thank you all for joining us today. And I just wanted to make that comment so everyone understands the context that we're bringing you this training in.
So thank you, Judge Diaz. I wanted to add a couple of things. First of all, I just put in the chat, that's the SAFE tool that I mentioned earlier. So if you click on that link, you can get it. If it doesn't work for you, let me know. I will send the actual tool out so that it can be distributed. Elizabeth asked about successful appellate challenges to the types of programs that we've laid out, which is a great question. And in full transparency, there currently is a challenge working its way up through the courts in Washington State around the use of the affidavits that we've been talking about. And you won't be surprised that it's a Fifth Amendment challenge, and it's that requiring a respondent to attest to their firearms possession is compelled testimony that could incriminate them if they are prohibited from having weapons for some other reason. Hasn't been addressed by an appellate court yet, so we don't know what's going to happen with that. We do know that there's some folks there's some strong arguments against it, and we'll see what happens. But there are also folks in Washington State who are looking at retooling their approach if it's deemed to be unconstitutional, compelled testimony in violation of the Fifth Amendment as to what they would do. I know that you all in Bexar County have had lots of very vigorous conversations around protecting respondent and defendant's rights, and have started to come to a kind of a consensus around what could work, which I really applaud you for, and I appreciate, because I was part of those conversations and I learned a lot from them that as well. So, but that's the only example I know. The kinds of prohibitions that we've been talking about have been upheld consistently, including by the U.S. Supreme Court, as allowed under the Second Amendment, as a reasonable restriction on firearms rights, basically for safety purposes.
Darren, and I was just going to follow up on that. You have worked with other jurisdictions similar to Texas that don't include a specific statutory authority for the surrender. And that's part of what we have been looking to as well. Can you talk a little bit about that issue? I think we all are aware that there's not specific statutory language within the Texas laws mandating a surrender or providing us the discretion to do so, in black letter law. So could you talk a little bit about what you have found in your work with us and other communities serves as our authority for this work?
Sure. Yeah, thank you for asking. And I think it's a little different everywhere, but I can give you a bit of an overview. And actually, places that have done what you are proposing to do, to order surrender despite the lack of explicit authority to do so, there's been no challenge sustained against those. The folks that have done that have been able to do it. And the highest it's gotten is in Ohio to the Supreme Court, the Ohio Supreme Court, which where there is no explicit authority in the statute around firearms, but the Supreme Court, in developing its forms, included a no possession and surrender provision in the statewide forms, which was put into place. And that was challenged. What the Supreme Court did was to put a restriction on it that didn't previously exist, but wasn't fatal to it, which was that there has to be a nexus between the person's possession of the firearms and that order to surrender. And so it couldn't be used in a blanket fashion in Ohio based on that court's interpretation of its law, which of course is not, maybe is, interesting, potentially persuasive authority in Texas, but not necessarily. But it still was allowed. Other places that have done this haven't had any of those kinds of challenges, and there are at least 4 or 5 places right now that have kind of robust surrender programs based on inherent authority of the court to issue orders that are necessary to protect the protected person and children. And so they rely on what we sometimes call the catch-all authority that's available in protection order codes to do so. And so that would be your basis in Texas. And I don't have it up on a slide, but to remind folks that the Texas Supreme Court, in its domestic violence bench book, has instructed judges that they should be doing this. And so that's a pretty strong indication that there's some consensus around your authority as judicial officers in Texas to take these kinds of steps despite the lack of explicit authority in the statute.
That's pretty impressive to have a Supreme Court behind this. We struggle sometimes in other jurisdictions to get the appellate judges to understand how important this is. Trial judges certainly understand, but appellate courts not quite as much. So that's a real strength for Texas and a real credit. And I think just adding to what Darren said, the whole purpose behind protective orders is to protect. And when you look at the inherent authority of a court to do whatever may be necessary prophylactically to protect a plaintiff, taking guns out of hands of somebody who might be using them to cause harm just fits very well.
Thank you both so much.
So anything else anyone wants to add? We'd love to hear from you. Any struggles you're having around this stuff that you want to voice and we can talk about?
I just have a question, Darren, on that case in Washington about the compelled statement for against incrimination. is the NCJ, FCJ going to file any briefings, or the Battered Women's Justice Project or any organizations like that going to file any kind of amicus briefing? Do you know?
Yeah, my understanding, no, I don't think any of the national organizations and we do sometimes, but not frequently. And I don't know that NCJ, FCJ would do it in this case, or the other organizations, but I do understand that there are amicus briefs that have been submitted by interested organizations in Washington State. I haven't seen any of them, but my understanding is that the perspective that, you know, there are reasons to do this is going to be heard by the appellate court.
Thank you.
But I can't speak for the National Council about whether they would be interested in doing that.
And is it at the Court of Appeals or is it at the Supreme Court? I'm sorry, I missed that.
It's at the Court of Appeals now, I believe. There is, yeah. So it was a case that came out of, and I can send it to you. It's a case that came out of, I think, Snohomish County. No, it wasn't Snohomish. It was a different county. But it's not gone to the circuit, to the appellate level yet. Or it has gone, but there has not been an opinion issued yet. At least as of when I checked about 3 or 4 weeks ago. So maybe something's happened, late breaking news. But I definitely wanted you to know about that. I mean, it's like I'm hoping that it's not going to go anywhere, but you know, that's the lay of the land.
Perfect. Thank you.
And I just wanted to add to that briefly. When we introduce you all to the forms and processes that we've developed here in Bexar County, you will note that the form that's at issue, or a form that we have similar to the one that's at issue in Washington, what we have done in conjunction with the defense bar is we've actually added an option for someone to check a box asserting their Fifth Amendment right against self-incrimination. So we have acknowledged that as a potential issue and addressed it in the forms and processes that we'll be proposing to you all. So hopefully it's not something that allows room for a challenge here in Bexar County as well.
Yeah, and I'm sure it would be a very different decision if that option were available in Washington State, and it's not. Their neighbor in Oregon has chosen to do that. And we've been working, Sue and I have worked with Vermont around a similar issue, and how to ensure that such a checkbox doesn't kind of swallow the whole thing, right? So that everyone just randomly checks it off, to try to explain to people that there are really limited grounds upon which to assert that privilege. And generally you're supposed to comply with these court orders. So, but this is an area that's in great flux right now, and we'll see where it goes. So I'm gonna note that we only have 5 minutes left. And Judge DeLeon, I'm kind of looking at you, and we haven't talked about the criminal side at all. So I hope what we talked about is applicable on the criminal side in terms of follow up with and in fact, with pretrial orders, you have a little more teeth you can actually use to ensure compliance and stuff. If you would like, we will be happy to come back and talk about the criminal side specifically with, you know, a subset of folks or this whole group or whatever works for you all. I apologize for not having the time to do it now. We will send you, I don't think we've distributed the slides. So I'll make sure that you have a copy that can be distributed of the slides, and you can take a look at the criminal side of things. But just consider an invitation if you'd like us to come and talk specifically around some best practices in criminal domestic violence cases. We'd be more than happy to.
Yeah, eventually that'd be great. So if you can give me those slides. And Monique, do we ever get Darren, you were talking about a sheet from Oregon or Washington so that a defendant knows, you know, do I turn in my firearm, or what do I do? Do we have one of those? What are they called? Frequently asked questions.
Yeah, I'll get you that stuff.
Have we started that, Monique?
We don't have one similar to the one he showed us, and I made a note that would be helpful. We have instructions for transfer, but we don't have frequently asked questions. So that would be a good kind of summary to have.
I think it makes for a good summary so that, you know, normal people, defendants, instead of lawyers, can figure out, you know, what they're supposed to do.
Right.
So
it's a good point.
definitely. Thank you, Darren.
Well, thank you.
Judge Diaz, I'm going to have to apologize. I have a hearing at, which is 2:30 our time, 1:30 your time. So I'm going to have to hop off and leave everything in Darren's good hands, but I would be happy to join Darren if you want a session on criminal, or Darren can, but, and it doesn't need to be an hour and a half. We could take a shorter block of time if that would be something you would prefer, but I really want to thank everybody for your time and great questions and participation, and wish you all the best of luck in the work that you're doing, because it is really impressive. So thank you for inviting me, and good luck to everybody. Thanks so much.
Thank you, Judge Carbon.
Thank you,
Bye-bye.
Darren. Let's go ahead and give everyone a round of applause. Thank you so much for your help.
Thank you.
All right, folks. So if you think of any questions after we're done, feel free to email us, and I'm sure that we can get some responses from Darren and Judge Carbon. We really appreciate all of your time, Darren. Thank you for all of your work here in Bexar County and for presenting to us today. We really appreciate it and look forward to bringing you back potentially to talk to the criminal judges specifically, and as we continue this work. So we'll go ahead and wrap up our session now. It is 1:28 p.m. and thank you all once again very much. I hope you have a wonderful rest of your week.
You too. Thank you, everyone. Take care.